Welcome to the lecture for Part 5-2, Chapters 22 through 26. Now, these chapters are relatively short, so I'm going to break them down and group them and talk about them all in one lecture video. First, we'll talk about Chapters 22 through 24, which deal with the use of polygraphs, the National Labor Relations Act, and the Immigration Reform and Control Act. So generally speaking, when we're looking at these first three chapters, we're going to be dealing with the interaction between the hotel and its employees. We're talking about both state and federal laws and both criminal and civil implications. So in Chapter 22, we look at the use of lie detectors by hotel management. Does it come up that often? Probably not, but it's something important for you to know about. We're going to look here at the general prohibitions outlined in the Polygraph Protection Act. And how they apply and how lie detectors function. So really the bottom line from the Employee Polygraph Protection Act, or the EPPA, is that in the vast majority of cases, private employers are prohibited from using the lie detector machine for either pre-employment screening or during the course of employment. And the Act gives an employee the right to refuse to take a lie detector test, and tells employers that generally they can't require that an employee take a test or discharge, discipline, or discriminate against employees who exercise their right not to take a test. Now, there are limited exceptions to the rule. For instance, lie detectors can be used under certain job descriptions that involve security, armored cars, alarm companies, pharmaceutical manufacturers, those kind of things. But again, the bottom line, the takeaway from this is that most private employers are prohibited from using the lie detector test. On to Chapter 23, which deals with the National Labor Relations Act. And here we want to discuss the principal functions of the Act as well as the rights it creates for employees and employers. And we're going to finish up talking about right to work laws, especially that in the state of North Carolina. So the National Labor Relations Act, or the NRLA, gives employees two basic rights, and that is to form, join, or assist a union, and then to participate in the activities of that. And under the Act, employers are required to bargain with unions or that collective employee group. The Act created what's called the National Labor Relations Board, which is the regulatory agency that enforces and administers the NRLA. And the last thing we'll talk about is under the NLRA, an employer can't take any adverse employment action against employees who engage in union activities. Now, you may be familiar with the fact that North Carolina is what's called a right to work state. And that right to work comes from the North Carolina General Statute, specifically Section 95, Article 10, which is called the Declaration of Policy as to Labor Organizations. So here's how these two things work together. The right of workers in private employment to form unions and to bargain collectively, as we said, is guaranteed by the NLRA, the National Labor Relations Act. But many states, like North Carolina, have laws which are called right to work laws. And this is where the state legislature has declared that under North Carolina law, the right to live includes the right to work, and therefore the right to work cannot be denied because of membership or non-membership in any labor union or labor organization. So in layman's terms, what we're saying here is you can't be required to join a union to work at a certain place. In non-right to work states, you can be required to join a union before you're hired on at a factory, let's say. So that's the difference between a right to work and a non-right to work state. And now we move on to Chapter 24, which deals with the Immigration Reform and Control Act of 1986. And we want to deal with some of the key provisions of the Act and how they apply to both employees and employers. The basic tenet of the Immigration Reform and Control Act is that employers are prohibited from hiring or referring individuals who aren't authorized to work in the United States. In addition, before hiring an employee, they're required to thoroughly check the identity and the authority to work of an employee. If you've been hired in the last, say, 15, 25 years, you have filled out what's called an I-9, or at least you should have filled out what's called an I-9. Every new employee, regardless of citizenship or immigration status, has to fill out that I-9 form. And from the employer standpoint, they have to keep those I-9s on file for everybody on their payroll, and they have to be ready for inspection by any authorized government. And as I said, you're probably familiar with that I-9 form, and that's where the employee and the employer attest that the employee is eligible to work, and the employer is required to take a look at certain documents. And they can include things like a passport, a citizenship certificate, alien registration cards, temporary, and there's lots of different things, and there's usually one from 3 different lists that has to be provided. But these are important documentation steps that employers have to go through, and as you can see from your reading and also from the screen here, violations can get very expensive very quickly on a per employee basis. Okay, let's round out today's lecture with chapters 25 and 26, which deal with FICA, FUTA, and federal income tax. And as far as immigration, what we're dealing with here is the interaction between hotel and their employees. We're dealing primarily, or not primarily, exclusively with federal laws here and exclusively with civil laws at this point. So Chapter 25 deals with federal Social Security, unemployment insurance, and workers' compensation. And Chapter 26 deals with the federal income tax withholding and reporting requirements for employers. So we're going to look at these 2 major federal employment taxes and the general nature of federal income tax. The first one is the Federal Insurance Contributions Act, or as it's commonly known, FICA. You've probably seen this on your pay stubs. And the FICA law mandates a payroll tax on the payroll checks of employees, and also mandates a matching set of funds from employees. And the whole purpose of this is to fund Social Security and Medicare programs. So FICA tax is taken directly from an employee's gross pay. In other words, you multiply the number of hours you work by your pay rate, and that becomes your gross pay. And FICA is based on a percentage of an employee's gross pay. Again, the employer matches that amount. The employer then keeps that amount that they've taken and the match amount, and they hold it in trust for the government. And then either at the end of the month or the end of the quarter, they're going to send those funds into the federal government. You can't opt out of FICA. If you could, everybody would. By the way, this also applies to people who are self-employed. They have to pay both halves of that tax as well. So from an employer standpoint, here are your responsibilities. First of all, withholding tax from an employee's compensation, paying the employer's contribution for Social Security and Medicare taxes, filing the appropriate tax forms, be it the 940 or 941, and paying the amounts, which are known as trust fund taxes, to the federal government at the appropriate. In addition to those requirements, the employer has to file that quarterly 941 report, provide employees with statements on the amounts that are being withheld, and then provide an annual reconciliation called a W-3 that sort of matches up with the W-2. And so that's going to wrap up Part 5-2, which covered, again, Chapters 22 through 26 for today's lecture. As always, if you have any questions, don't hesitate to reach out, and I hope you have a great day.